Good evening, class and professor. Welcome to my presentation, The Fourth Amendment and the Right to be Secure. The Constitution and the Bill of Rights are one of my favorite things to discuss and debate, so I'm excited to do this presentation for you all. This is one subject that I'm very passionate and vocal about. The Constitution defines, secures, and protects the rights and liberties of every U.S. citizen. This has been established since the founding of our country. What makes up the Constitution? What rights are outlined in the Constitution? The U.S. Constitution is considered the supreme law of the land. The first 10 amendments make up the Bill of Rights. These are rights that protect individual liberties. Every U.S. citizen should know and understand these rights that are granted to them. This also includes the very important amendment, the Fourth Amendment. The Fourth Amendment, the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, the persons, or the things to be seized. This is a lot of information to take in at once, so let's break it down and discuss a few key terms to get a better understanding and to better interpret what it says. Important keywords embedded in the Fourth Amendment that need examined are secure, effects, unreasonable, affirmation, and probable cause. So secure basically means to fix or attach firmly so it can't be moved or lost. So you're securing your rights to your property and possessions. Effects, as defined in this, means like goods, movables, or personal property. Unreasonable is another key term. It means not guided or based on good sense, or it's beyond the limits of fairness. An oath or affirmation is a process of affirming something is true. Probable cause is a very important key term. According to one of our readings by Rutledge, probable cause means reasonably reliable information to suspect there is a fair probability that a person has committed a crime or that a search will reveal contraband or evidence. So probable cause means that there is sufficient factual evidence information that a crime has been committed and who did it. So let's put this all together. The Fourth Amendment states that it is a right to keep and not lose any property or part of yourself or anything that belongs to you, and that this protects you from unfair searches and seizures that are not based on good sense, and that warrants must be based on reliable and reasonable information and evidence, and that it is sworn under oath or affirmation to be true and accurate, and the warrant must specify the place and persons to be searched and what can be seized. This is a whole nother discussion topic, searching or seizing things that are not specified in a warrant and what is allowed and what is not. But I would like to discuss the warrant a little bit more. It is a legal document typically issued by the judge and magistrate that authorizes law enforcement to make an arrest or search and seize. The Fourth Amendment provides that no warrants shall issue but upon probable cause. The Constitution doesn't furnish any definition of probable cause, leaving that task to the Supreme Court, which has also applied the probable cause standard to certain warrantless activities. And this was according to the paper we read by Rutledge. He also said that a warrant is required and when it is not. A probable cause is the level of information and suspicion that justifies the warrantless search of fleeting targets such as cars, trucks, buses, trains, airplanes, and boats. So this is when one incident where you can search without a warrant. Other valid searches and seizures without warrants includes a detention short of arrest, like stop and frisk or search incident to arrest. This also includes vehicular searches and vessel searches, so moving objects. Also includes consent searches. So if they ask you, can we search your car, and you say yes, well then they don't need a warrant because you gave them permission. This also includes border searches, so people coming across the border are subject to search and they don't need a warrant. This includes open fields in plain view. So if they're in your house and something's sitting out in plain view, or if it's out in public view where they can see it, it doesn't need to. It also includes public schools, government, or workplaces. This also includes prisons. That's another good debate that I like to talk about is prisoners and their constitutional rights and what's infringement on it and what isn't. But in prisons, this right to search and seizure doesn't extend there, and also certain cases of probation and parole if it's part of their regulation also. And this includes drug testing, so that's why when you get stopped and there's suspicions of DUI, they can get a breathalyzer without having a warrant. So what happens if the right of an individual that are protected by the Fourth Amendment are violated? What constitutes a violation? There are two main things that can occur that would be a violation. A violation of the Fourth Amendment can occur by illegal search and seizure or not having probable cause. Examples of illegal search and seizure are when you search a house without a warrant, or certain things without a warrant, or if you search things that aren't defined in the warrant or seize things that aren't defined in the warrant. So for example, if a person owns a main house that they live in and have a rental property, and you search both properties but only their main residence is listed, or if you, for example, use the warrant to search their house and use it to search their business too, that would be a good example of a violation. These violations can be addressed during the pre-trial motions. As stated by the paper we read regarding pre-trial motions from 2012, after the preliminary hearing and before the criminal case goes to trial, the prosecutor and the defense team usually appear before a criminal court judge and make pre-trial motions. Arguments that certain evidence should be kept out of trial, that certain persons must or cannot testify, or that the case should be dismissed altogether, are done during this time. This is where the defense lawyer can get evidence excluded or even file a motion to dismiss the case. If the lawyer can demonstrate that the evidence obtained was in violation of the Fourth Amendment, the evidence will then be excluded and cannot be used against the defendant in trial. Often this results in the case getting dismissed or the charges dropped. Now, I did want to include this little extra tidbit of additional information. These constitutional rights have been around since the founding of our country. The founding fathers could not fathom the technology and advancements that we have in modern society today. So how does the Fourth Amendment apply to digital data and privacy? I did a little bit of research on this because it's a hot topic of debate now, what the government is allowed and can't do, and the Patriot Act and how that violates certain things. But I found this great paper written last year, 2019, by Carthu, that says, as we stand in the midst of an exponential growth in modern technology, the law must advance in step. A strict application of the third-party doctrine would result in none of us having a legitimate privacy interest in almost all of our digital data. In our increasingly digital world, this would leave Americans vulnerable to the kind of Orwellian government surveillance that the majority was concerned about in the Carpenter case. While Carpenter takes a step towards preserving individual privacy, the opinion makes it clear that this application is intended to be narrow and does not wholly eradicate the third-party doctrine. So this made mention of the Carpenter versus United States and this quote, and it is an interesting case that addressed utilizing information from a cell phone for tracking, and it was deemed a violation by the U.S. Supreme Court since it did not have a search warrant to access the phone's data. So a lot of people use this to argue, about our emails and other aspects of digital data that we use. We save a lot of documents and pictures on our computer and transmitting through the internet. So this is wanted to apply the Fourth Amendment to this because this is a good topic of debate. In conclusion, The Constitution is a powerful document that protects individual rights. These rights cannot be restricted or denied. Knowledge is power, and every U.S. citizen must learn and understand their rights. Then they must remember the value of these rights and cherish them. People do not protect things unless they find value in it. Your rights and liberties are the most valuable thing that you possess. And since knowing your rights is so vitally important, I can't reiterate it enough. Therefore, I have included this photo in my presentation because it is a simplification of the Bill of Rights, which is a great teaching tool for children as well. And I wanted to highlight that I was talking about number 4, which covers the investigation part of the criminal justice system, arrests and searches. But 5, 6, 7, and 8 go through the whole process of the rights of a person who are being accused and the rights for them in their trial and to have an attorney and about their bail and punishments. So these are good ones to consider. As I mentioned, this is a great graph to use to teach children. On a personal note, I think that we need to go back to teaching more U.S. government and law and the Constitution and Bill of Rights and all that stuff to children to teach them at a young age. This is my last slide listing my references, and I would like to thank you for taking the time for watching my video, and I hope you enjoyed it. Have a great evening.